Welcome to the Tennessee Arts Commission's Title VI training for FY14. This year's training program is designed with some flexibility options for you and your organizations. The slide presentation and the additional fact sheet will be made available for downloading off our website after you have gone through the training. If you need additional accommodations such as translation services or large print, please contact the Arts Access Program Coordinator. This year's Title VI training is obviously for all recipients of federal funds are required to comply with the provisions of Title VI. That is, anyone who receives federal dollars, either directly or indirectly from the federal government, must comply with the provisions of the law. This includes grantees, contractors, and state agencies. A grantee would include any paid or volunteer staff. Any board members would also be considered part of the grantee. The training must be documented, and you're to keep those records for 3 years. Training can be conducted in-house via an in-house training program or via the Tennessee Arts Commission's training program. Contact the agency's Title VI training coordinator for details. Training should be completed prior to grant closeout process. The Tennessee Arts Commission's Title VI policy and discrimination policy is that the Title VI of the Civil Rights Act of 1964 is the federal law that prohibits discrimination based on a person's race, color, or national origin. All commission grantees are subject to compliance with this and other applicable federal laws. There are other laws that may be in effect as well, but this is the one that is in particular to a person's race, color, or national origin. Discrimination practices can include denying an individual any service or benefit, providing a different service, aid, or benefit, or providing them in a manner different than they are provided to others, segregating or treating individuals separately in any manner related to receiving program services or benefits, retaliation, or LEP, which is limited English proficiency. In the FY14 training, we're going to be talking about a specific area of the civil rights law, and it has in regard to what's called disparate treatment versus disparate impact. Disparate treatment is when you have an intentional discriminatory practice. Those were the practices that I mentioned earlier. This is disparate treatment. For example, intentionally treating someone different at a venue or arts event or programming. This kind of discrimination may not be as prevalent in today's society, but can still occur as it relates to race, color, and national origin. Disparate impact. This refers to policies, procedures, rules, or other systems that appear to be neutral. However, if the effect of these activities has a disproportionate impact on said protected groups, this is disparate impact discrimination and is prohibited by the Civil Rights Act of 1964.